I'm a bad mood, gotta keep it tight. Hold my baby squid, keep him out of sight. Talking about my life, government, stay away. If you drive, I'ma do it my own way. Squid in the ocean, swimming all alone. Ain't nobody telling me where to go. Living free, gotta stay true to myself. No need for interference from anyone else. Squid pro quo, that's the way to be. Living on my terms, setting myself free. I'm to my baby, protecting with my no government intrusion. I control my life.
Hey everyone, it's Squid. Welcome back to the channel on this Tuesday morning where I need a nap. So if I look tired, it's because I am tired because, I live my life tired. So not that I have any sponsors, but if Celsius wants to sponsor me, dude, I drink like 2 of these a day. I don't know if I'd survive without Celsius. I tried to get the little down for a nap. She is right here because obviously that didn't work out so well. So we are going to talk about Maya Kowalski today. This is a case from 2023 that I watched all of it on Megan's channel. But it is in appeals right now. Maya Kowalski, for those of you who don't know, a little TLDR, was I want to say she was 10 at the time, was having a lot of pain, unexplained pain. Her mom was a nurse. She has a younger brother, and then her dad. Well, they could not figure out what was wrong with her. She had been diagnosed with CRPS, which is complex regional pain syndrome. For those of you who know, Mo in the Deep End, Mo in the Deep End is the resident expert on CRPS, considering she is a CRPS sufferer. So, for all questions related to CRPS, I will ask her because she knows way more about the ins and outs. I know from the treatment side. However, Beata Kowalski brought her 10-year-old daughter. I believe she was 10 at the time. It's been a couple years, so details are a little sparse from time to time. However, she brought her daughter to Johns Hopkins All Children's Hospital, further known as JHACH. And JHACH not only said she didn't have CRPS, but accused her mother of child abuse. And long story short, this is a case of medical kidnapping. This is a long story long, let's be honest here. Maya was in JHACH for about 4 months. They wouldn't let her mother see her, talk to her. They would not give her mother, at one court hearing, they would not give her mother the opportunity to give her daughter a hug. And Beata, later that day, went and unalived herself. And shortly thereafter, the child, Maya at the time, was given back to her father. And so they decided to sue JHACH, and they won $262 million. They sued for like wrongful death. It's long drug out. JHACH's lawyers, Ethan Shapiro, and the skeleton hider, what's his face? I just can't. This was personal. Like I said, this one was like, yeah, that's no chump change. However, there are some new docs, and we fell in love with Nick Whitney and Anderson, Greg Anderson. They're the lawyers, and yeah, this one was. And hey, Mrs. Yoda, this this one was on the news. I mean, y'all are in Florida, you know, it's Sarasota County. But there's been a whole they've appealed it, and this is somewhat new territory for me, considering I don't generally cover appeals. I have been lately because a lot of my cases are going to appeals, but I am not as familiar with the process of appeals. And I know you go in front of a panel of 3 judges, and it's, you know, I know about appeals, but I don't know breaking down the districts in Florida, because this is the District Court of Appeals of the state of Florida, 2nd District. So I am not an expert by any means. However, that's where we're going to learn together, because there is some documents that are out, and some that I've seen, but like I've heard the terms before, but it's a little complicated. Even, well, I say even for me, I'm not a lawyer. I am not that bright. I just try to break things down into the simplest way possible. So some of this stuff, we're going to break down. And good morning, Cheryl. Hope you are staying safe. It seems like everybody appeals. And yeah, and it's kind of one of those things of, generally, when I've been court watching before I started a YouTube channel, I would keep track of like, oh, this person's appealing, but I wouldn't really follow the process and the documents and finding out all the ins and outs and everything that's kind of gone on behind the scenes. Whereas here, I'm going to show you the docket for this case. This is, again, Florida. This is Sarasota County. Relatively easy to find the documents. But this case goes back like there is exhibits and exhibits and exhibits and exhibits. You can see I'm only half the page. Oh my goodness. So this just goes back to 2022. Like, there are documents that go back to I'm sorry, 2018. So we're going to just investigate. The last time I talked about this case, it was Nick Whitney, my personal favorite lawyer from this case, filed a motion to withdraw and got kind of dramatic about it. So we have a little bit more info, and I know people didn't like me talking about the fact that Nick Whitney and Greg Anderson might not get along. However, I report court cases, and that's a pretty big turn in this story as far as filing the appeal. So if y'all don't like the fact, and I have no personal connection, I've never spoken to any of these gentlemen. So once again, I have no loyalties to people I don't know. I will say this, and this relates to the conversations from yesterday as well. I have no loyalties to people who I am not friends with. Am I out to make enemies? No. However, this is news. I will report this because I am interested in this case, and I want to see JHACH pay. So sorry if there's something that is in this case that we don't like, and that we don't like that there's drama between people that we like. But guess what? That is life. And I do have my band hammer out today. So if anybody wants to get off topic or create drama with any other member of chat that you don't agree with, remember, PS, FYI, whatever you want to say, just because someone doesn't have the same point of view as you or same opinion as you does not make them a troll. And although we can agree to disagree, if you start causing drama in my chat, I don't care if you're a friend of mine or not. I will time your butt out for an hour, which means that you won't be coming back until tomorrow, because there's a lot here and I plan on trying to get through it relatively quickly. I sent you a picture of Coco Trick. I was laughing so hard. One walking them stop. She was doing show her butt. And I think I got sent that picture. I know I got sent that picture by more than one source. So let me look. Because I was trying to get her done for a nap. So the last oh my goodness. That's funny. Oh my goodness. I got a picture of a Coco butt. Oh, and Coco is bigger than I thought she was. Mrs. Yoda also sent me a picture of when they went on the fishing trip on, oh, I'm getting my days all mixed up. Was that Sunday or Saturday? Of Coco made her sit in the back seat because Coco wanted to ride shotgun. I'm cuckoo for Coco butt. You mean I have the chance to get yeeted from chat? Well, you know. We'll see. Just stay on topic, and just because someone doesn't agree with you or agree with me, I always say it and I'll say it again. There are people who are watching my chat or who are watching my streams who may not like me. And one, that's okay, because there's 7 billion people in the world and you ain't gonna like everybody. And secondly, if they're in chat and they're civil, they're getting the opportunity and they're taking the time to make an effort to hear an opinion that they might not agree with. I cannot fault anybody for that. Girl, you're going to step on that. You're going to break it. No. Go put it in the dishwasher, please. Go put it in the dishwasher. Yes, ma'am. Dishwasher. Or just put it on your head. That'll work. Hey, Starzy. Oh, jeez. You Flash fan, you know what I mean. Weirdest breakfast cereal there ever was. She just ate toast sitting down here, and she wanted to stand on her. She wanted to stand on her plate, and that's a no-no. Gotta go. Wanted to hit like. Take care. Take care. Stay safe. Yeah, Mayo was when I was first watching. Yeah, and there's been a lot. Like, I have to go back up to the top. We're not going to get in. Baby girl, can you go put that in the dishwasher or give it to me, please? Okay, or just sit it down. You're not going to throw it. You break my plate, we're going to have a problem. Oh, boy. I'm going to tell Daddy. Oh, that got your attention. Mr. Coop and Georgie Raid. Hi, guys. And I have to make sure that oh, come on. I don't ever think that I even went to my YouTube studio to make sure I shared this. Yeah, breaking the fine china. Yeah, the Walmart dishes. Hold on. Hey, Georgie, is everyone behaving so far? But we haven't really got into anything. And remember, as Rogue Mama, you changed your name back. As Rogue Mama says, just because someone doesn't have the same opinion as you does not mean they're trolling. Sometimes people just disagree, and guess what? If they're respectful, I don't care. Yeah. I found Rogue Mama Rosalind and became a mod for Megan and actually spoke to Megan with Maya. Before that, I would just casually watch her channel, but like that's when I became like watching Megan all the time. And I don't get to watch anybody as much as I used to, which is kind of sad, actually. Do. Come on. There we go. Control room. Whew. I found Mo through this trial, which is how I found Flashman. Yes, and opposing opinion isn't being disrespectful. Are you going to try to fax some more stuff? She's starting to play with the printer and try to send faxes out. I don't know. So the first thing that I want to show you before we get into any detailed, because there's a couple of motions that are long and we're not going to go through all of them. We're just going to hit the high points. The first, Georgie, I have something for you. I have to I just saw it when I went to open up my YouTube studio. I'll do it from my phone. Yeah. So, yeah, that person commented back, and it was just funny. I'll share the comment with them later. So this is it. I at first thought they were apologizing to me, but God knows we can't have that. So, so this is District Court of Appeals for the state of Florida, 2nd District from Tampa. By order of the court, this case is provisionally set for an oral argument on February 12th, 2025 at 9:30 before Judge Edward C. LaRose, Judge Anthony K. Black, and Andrea T. Smith. Oral arguments will occur at the 2nd District Court of Appeal in the courtroom of Stetson University College of Law. It gives you, they also in this document have the link to the 2nd District Court of Appeals website. I don't know if it'll be streamed, but I'm sure as heck gonna look for it. Yep. February 12th, which is Wednesday. So that'll be the first one. And of course, this panel is subject to change without notice. Should the assigned panel of judges decide that the court will not benefit from an oral argument in this proceeding, the attorneys or parties will be notified by order no less than 2 weeks before the scheduled date. And then it goes into if this is a criminal proceeding. So this was filed back in December. So all the lawyers got served. Ethan Shapiro got served twice. I don't know. This is just a shit show in the making. As of now, I don't see any reason why this should get dismissed or they shouldn't hear oral arguments. So this is kind of one of those like this is this was the civil suit. And they JHACH is not paying at all what they owe, and they're still saying that they did nothing wrong. Oi, 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 oi. And while this is an appeals, I shall remind you that this judgment is accruing interest. Every day, Scott used to have an interest counter. So, Young Hero, thank you for the $2 super chat and not making me say any words. I need Megan Fox shit Piro voice. Yeah, I can't do the voices. They give me I don't have a voice changer. Yep, before a 3-judge panel. It is the then there's this one. This was from thank you, Young Hero. And this was from January 9th. So let me make it bigger for y'all. Yeah, she's something else today. She had her banana today, and then she was mad that when she wanted another one, I said no. Um, it There might be a stream. It should be, but I don't know. Um, I am not super familiar with appeals courts, and this is one of the reasons that I kind of wanted to cover this was because I want to learn. And what better way? Yes, so many good memes. Uh, what better way to learn than to read and do it? Because watching somebody else is not going to help me learn. And I honestly, besides Megan sometimes showing um, her sister's work, um, I don't really ever pay that much attention or know anybody that streams the appeals process. Some probably do. I'm just not familiar with anybody who does. Um, they don't usually stream them. Some do. And there is a we'll go to that second court of appeals website and we'll see, because I haven't been there yet. I clicked on it and that was it. Um, the question is the interpretation of Chapter 39, which is the Florida statute covering immunity for reporters of abuse, also regarding excessive penalties. And you are my as an expert on that, because I know nothing. It may not be drama, it may not be a matter of finances, and this is there's a lot that could be, but judging by the way that JHACH's lawyers acted, you want to see a sleazy bunch of people? Sleazy bunch of people? Go back and watch Megan's playlist on Take Care of Maya. This case is about and correct me if I'm wrong, but I believe she was 10 years old at the time. At the time, she was suffering a lot of pain. Nobody could tell her the source of the pain. She was ultimately diagnosed with CRPS, complex regional pain syndrome. And she was her mother took her to JHACH, where the child abuse pediatrician, Sally Smith, decided that Maya's mother was abusing her. And not only didn't allow her to see her daughter, Beata ultimately unalived herself in order to what she viewed, and I'm not putting words in her mouth and I can't speak for her, but what I would assume as trying to save her daughter, sacrificing herself for her daughter. And at the time, I also view this case a little bit differently now. At the time I was watching it, I was viewing it from a healthcare professional. I was a therapist or an OTA on acute care, dealt with difficult patients, and that's what they viewed her as, a difficult patient. I understood from what the therapist that testified, I understood their mental process behind it, but I also understood that I thought JHACH was shady in the way they scheduled people. And there I was just viewing it from the health care side of things and someone who has also chronic pain. Yes, there's a Netflix series called Take Care of Maya. Yes, and guess what? It happened in Florida. We'll get to that. I did find something that oh yes, Kathy Beatty. We can't forget Kathy Beatty. It's been so long since we've talked about this, and the last time I did talk about it was in July when there was an order for withdrawing his counsel from Nick Whitney. And yes, and Maya is now 18. She did win, but JHACH is appealing. This case is where the dumpster Jesus reference comes into play, because they literally threw what Catholics view as the body of Christ in the trash. So, yeah. So this is what really got me into this is what really got me into looking at CPS and CPS abuses. And that's what Megan specializes in. So that's what I was like really focused on Megan's channel for. I am no expert in that area. She is. She has done it for many years. A lot of people just seem to think that she only does like What the Hales and Laura Owens. It's like, no, she has a pretty lengthy track record of cases that she's been following for years. And this was one of them. This is one of the trials that she streamed. I personally believe a lot of things went wrong with the entire handling of the case, but to do with the JH attorney regaling Florida Statute Chapter 39 argument. In short, I believe a new trial will be ordered. And the thing is trying to find in these documents, is a lot. Yeah. Sally Smith settled out of court and did have to pay. And there's a lot of various players and pieces in this situation. And a lot of you, oh yes, along with the chocolate cake, God forbid we give a little girl chocolate cake. Kathy Beatty was just sleazy in the sense of like, I've never felt the need to hug a patient or like put a child that wasn't mine on my lap. Like, it's just, there's just so many other things with that Stetson University is your school. And Jeff, I know you've told me what you did before, and I'm so sorry that I forgot. I know that, are you former law enforcement or are you a lawyer? I can't remember. And I apologize for not remembering. That's my poor recall. So, I remember names and I remember some things people have said or they have a knowledge in a particular area, but I don't exactly remember what they do for a living. So there is just so much to this. Like, this is all the and there has been so many like orders. There was supposed to be a motion for sanctions in the they threw out the cake because they felt it had ketamine in it. That's also where I met Hey Joe, was this trial. This is where I've met a lot of you guys. I chose the investigative side with organized crime FDLE. That is way over my head. That is an area I am learning this as I go. This is something that interests me, but I am by no means an expert. And all these appeals and like all these documents are things that John drop kids. And that's also where the the meme of marked safe from being dropped by John Hopkins today. That was my first and pretty much my last meme. I made that meme and Megan put it on her channel. She brought it up in one of her streams and I was like, Also watching the depots, then them in court was interesting. Yeah. So back in July, there's just been a whole lot of, the coven. They all wore the same color and it was creepy and like, so we're going to skip some of it because there was supposed to be a sanctions hearing in October 9th in front of Judge Carroll, the Tuft of Justice. And that was canceled. And that was that was the last time that I paid any attention to this. But we're going to go with the first motion for relief. And I will post all of these in the Discord server. I meant to do it last night, but I just got way too tired. This was filed 11/14. I'm trying to put the dates when I save these files so that when I look at the all the documents I have and I go to put them in the Discord server, it makes sense and you can look at them in a chronological order instead of just having a bunch of documents and not knowing if I did them right. I retired 16 years ago and finally sleeping without interruption from calls all night. I've never had that because in my line of work, the good thing about being therapy over like a nurse or a doctor, is no one likes to get up and go for a walk at midnight. So we only work first and some into some second shift, but mostly, like 5:30 is the latest we work. So I never had that problem, but I've watched enough true crime and Lieutenant Joe Kenda to know that y'all get calls at all hours of the night, and that is not a job that I would ever want to do. Plus, you see things that you cannot unsee. Oh, and for those of you who have asked me if I'm covering the Lori Daybell stuff, I am not. Generally, I like pro se defendants because I think it's rather interesting and kind of funny because it sometimes turns into a shit show. However, there is something about being a mom and child unalivers, especially women, that just makes me a little. I would want to throw my computer against the wall. Like yesterday, I was talking to Rogue Mama, and I said, "Do you ever want to take your computer, put it through a wood chipper, and just tell everyone to go f themselves?" That is how I feel when I watch a child abuse case, unaliver. The people who have been accused of child abuse when they didn't do anything interests me because that's an overreach from the state. And I like to call out overreaches of government because that's one of my favorite things to do is say how corrupt our government is, and prove it with receipts and facts and cases and all of that stuff. But like watching the trial, like the treadmill case, I had a hard time watching that one because it's just, the child didn't do anything wrong. Children are innocent. Do we get frustrated with them? Yes. However, well, this is a little bit different. Christopher Schultz is out of Arizona, so it's very difficult to get any documents because it's Arizona. However, Christopher Schultz is a hot car case. He left his toddler in her car seat in Arizona in July because she was sleeping. And because he didn't want to wake her up and have her throw a tantrum, basically. And that is where he left the car running, the car shut off, and that is where she took her last breath. That poor child. However, that case is a little bit different because that is what could be an accident, not intentional abuse. So there's a difference. It's a slight difference, but it's Danny On is covering. So if y'all want to see the Daybell, go to Danny On. John, could you drop her link? It's one of those situations of that one's a little bit different because being in the South and in a hot climate, I have actually left baby Squid home with her dad when I've gone shopping, and knowing she wasn't there, I still had this mini, oh my God, did I leave her in the car? It's like, no, you actually got the opportunity to go shopping by yourself. So it's there's a fine line there, but accidents can happen. And there's a fine line on whether this was an accident or this was negligence. Still different to me than intentionally afflicting or unaliving a child. Like Daybell, like the dude who made his kid run on a treadmill until he passed out. Things like that. Or the Ruby Frankie stuff. That's intentional infliction of emotional and physical abuse, where the Christopher Schultz thing was kind of was it negligence or was it something that can happen to any parent who is busy and has 800 things going on at once and multiple children? So it's kind of a psychological difference for me. So it seems like a small difference, and some of you might look at it and go, that's not really a difference at all. to me, there's an accidental death versus a intentional affliction of, putting duct tape around someone's arms and legs. Like, big psychological difference in how I process those two different things. Both sad, but one doesn't make me one I can empathize with, being a toddler parent in a hot climate, and that's my greatest fear, versus actually purposely doing harm to a child. All right. So there's just this weird conundrum that I find myself in. And plus, with the Ruby Frankie stuff, Megan read the journal on her channel. I think she did a local stream, so that because of the content, and it was bad. It was bad. Like it was bad. All right, so this was filed on 11/11. And I know we're kind of going out of order, but there are some documents that are like 500 pages long, and we really don't have the time to go through them. I will post as much of them as I can, and I will probably post because Sarasota is really easy. You just click on public, and then you type in the name, and you click on the case. So it's super easy to find. So if you want to look at the 500-page document that I'm sure Discord will not let me upload because it's too big, I will post the link to Sarasota's clerk's website. Florida is relatively easy to find documents because they're Florida. Let's see this tab. Plaintiff's motion for relief from setoff. Plaintiff Jack Kowalski, individually and personal representative of the estate of Beata Kowalski, and Maya Kowalski, individually, by and through undersigned counsel, hereby move this court, pursuant to Florida Rules of Civil Procedure, to 1.540A, to enter an order granting plaintiff relief from the setoff provision as related to the medical negligence verdict entered November 9th of 2023. In support thereof, state one, in an abundance of caution, plaintiffs themselves suggested the issue of setoff, thinking it applied regardless of the lack of Fabry determination. And this is where some of these things that are being brought up I'm not familiar with. So this is where we go to a law dictionary and we Google it, and we look up stuff. Danny is awesome. The only reason I don't follow Danny as much as I should is she's in Utah and she streams after I'm in bed. So my new car alerts me after I turn it off. I open the door and I have my work bags in the back seat. In technology these days. Technology. Cat and Ray. Hey, Elu, thanks for the $2 super chat. Popping in to support you with a little monies. Appreciate you. And for every $25 in super chats. I love these things, but I will not eat them unless I'm forced to eat them. But I did buy them. So these deep fried garlic cloves, they're delicious. And then I do want to thank Duncan Idaho for the 5 gifted Squid Protocol memberships. I am doing more members content. I did a members live stream last night. I am working on it. Yeah, I'm usually asleep. Yeah. With her going to bed about the same time as her father the last few days, she's getting up earlier, which means I am getting up earlier. Ugh. Yeah, and this is something that is okay. This is something that I have an issue with on all sides, kind of like I did with the GA1 stuff. These are things that are just, like, I haven't seen receipts, so I refrain from commenting on things where I haven't seen receipts. One side tells me I have no right to look up, I had somebody comment this morning that I have no right to look up documents and blah, 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 and that I should do my research. Well, I did a GA1 stream, and I did research, and I am not going back to 3 years of BS with all of those people because I don't have the time, the patience, the wherewithal. I don't give a damn. And secondly, this person this morning was like, I see you're trying to be biased, but you're not. I feel the need to make a statement on that one. I'm trying to be unbiased. However, it's a little hard to be completely unbiased when one, I can read a document and have an opinion on it. And secondly, when one side attacked me and the other side did not. So if one side went after my child and thought it was okay to attack my child and threaten me, the other side has not done that. So as much as I'm trying to be unbiased, when one side attacks me and one side doesn't, I'm going to lean towards the side that doesn't attack me. You want toast? Okay. Research includes cases and associated documents. I will read the exact phrase. I had never seen this person before, and when they said something, my response was bye. Like, okay, like I'm not forcing you to be here. I didn't know who you were like 5 minutes ago. So looking up core docs is research. Yeah, and I also was talking to Coop and Georgie this morning on their stream, and it was like I'm looking at it from, because I don't have the time, the effort, the energy, the give a shit to go back to 3 years of videos in this when I can barely keep up with who I follow. Like, I'm a mod for a few people and I feel so bad because I haven't been on their channels in weeks. So I don't have okay, I did watch part of her video, but see, even that, like I turn on her video and I get busy doing something. So I'm like half in and half out. And we all know, I've talked enough about the brain to talk to you guys about, if you aren't attending to something, it's very hard to remember it. So I hear bits and pieces. So I don't have the time, the effort, to give a damn to go back for 3 years. So I'm viewing this as a jury member and the judge. And remember, and even though there's context, and I know there's context, y'all tell me every day that there's context. The problem is the jury only sees what the context, the jury only sees the context that the judge lets them in, or that the judge lets them. That's where the documents come into play, because the jury only sees what the judge lets them. So the jury may not get all the context. And that's kind of where I'm like, okay, I can take my limited knowledge about the last 3 years, because I had no idea any of these people existed, into viewing it from the jury's. You're not having this one because you spilled it once already. Yeah, we're going to go get... No. I will fill that one up for you. I'm going to go get her some toast. I will be back in a hot second. Thank you for your patience. Go grab a snack.
Our hearts beat to the city streets. We began to feel the fire. We rise like tall buildings as the chemicals, they take us higher. The night's young, it has just begun, as she puts her hand in mine. We wanna chase the night, wanna dance to the light, pull the stars from the sky, just two hearts running wild. Never sleep, never stop, as we shout from the top. We're gonna be two hearts running wild. Now the morning is the afternoon. We lay awake in bed, the glass so loud as the hours pass. We're gonna do it all again. We wanna chase the night, wanna dance to the light, pull the stars from the sky, just two hearts.
Hey guys, I am back. Thank you for your patience with me. I appreciate that so very, very much. Yeah, do squats. Yes, and speaking of that, I really do need to start getting back into working out. Yeah, I did see that email. So, but my point is the I can't completely go back, and also I am one of those people where like I believe it, but I believe it better when like it's in my inbox. So I'm a little, yeah, yes. So getting back to um yeah, right there. Right there. So in abundance of caution, plaintiffs themselves suggested at the issue of setoff, thinking it applied regardless of the lack of Fabre determination. 2, this was a mutual mistake as neither party brought up the convoluted law, and thus a $2.5 million setoff for settlement applied to judgment was included. 3, up until 2006, Florida recognized the doctrine of joint and several liability with respect to economic damages in negligence cases. In 2006, Statute 768.81 of the Florida Statutes was amended, and it now states, in a negligence action, the court shall enter judgment against each party liable on the basis of such party's percentage of fault, and not the basis of the doctrine of joint and several liability. Florida Statute 768.81, paragraph 3. Sorry, she's scrolling through shorts, and sometimes I wonder where she finds some of the stuff that she finds and why people make the videos they make. The effect of this amendment was that Florida did away with the joint and several liability for economic damages in negligence cases. The change to this statute has resulted in a shift of how courts approach setoffs of future verdicts against non-settling defendants where co-defendants have settled. So, hey, poor Marine. It is well settled in case law coming out of the Florida Supreme Court that settlement dollars are not synonymous with damages, but a merely contractual estimate of the settling tortfeasors. Some words I'm like, I know what they mean, but I can't say them, and some things I can say them and I don't know what they mean. Yeah, this is one of those cases that I haven't kept up with all the appeal stuff like I should. And like I feel like I wanted to, but this is one of those cases like some of you What the Hales people who have followed this since the beginning. I heard about this case back in like 2020 through some media or something. So when I saw Megan covering this case, I had an idea of what it was about, and I followed it like everything from I watched every court date and every day in court from the time the parties walked in to the time they walked out. Every day for what was that, 3 weeks? So it was a big one. It is well settled in case law coming out of not synonymous with damage, but merely contractual estimate of the settling tortfeasor's liability. They include not only damages, but also the value of avoiding the risk and expense of trial. Given these components of a settlement, there is no conceptual inconsistency in allowing a plaintiff to recover more from a settlement or partial settlement than he could receive as damages. Wells v. Tallahassee Memorial Regional Medical Center, 2nd District, 1995. And I really do need to learn how to easily find these the case law that they're using, because sometimes I want to know if the case law they're using is actually appropriate, because I'm sure that some lawyers it's not an appropriate case. It is if taken out of context. In accordance with the above stated principle, Florida courts consistently reject the argument made by non-settling defendants that failure to apply a setoff to future verdicts creates a windfall for plaintiff. D'Angelo v. Fitzmaurice, Florida 2003. Thus, just because a co-defendant has settled with a plaintiff pertaining to a negligence action, does not entitle a non-settling defendant to set off damages found by the jury or jury in the future. There were multiple, like, they sued JHACH, but they also settled with Kathy Beatty, and among others, for this action. So there's a lot that goes into that 262, and I believe it was offset or it was reduced by the judge to like by 20 million or so. Hey King Paco, how are you? For example, in the 2016 Suarez decision coming from the 2nd District Court of Appeal, the Court of Appeals found a trial court erred where they permitted a set-off to reduce jury-awarded economic damages by the amount previously paid by the settling co-defendant. Port Charlotte HMA LLC v. Suarez. The trial court in Suarez relied on the decision in D'Angelo where the court permitted a set-off against an economic damages in a medical malpractice action. The 2nd District Court of Appeals in Suarez clarified the trial court's reliance on the D'Angelo decision could not stand as D'Angelo was decided before the 2006 revision to Statute 768.81 went into effect. Additionally, some courts have gone as far to say that non-settling defendant was not entitled to discover a co-defendant settlement for the purpose of offsetting the non-settling defendant's verdict. Shippers v. U.S., Middle District of Florida, 2011. The court further explained if the non-settling party had a judgment entered against them, since Florida has abolished joint and several liability, the judgment against the non-settling party would be based on the non-settling party's percentage of fault. That's an interesting... I can set up an errand and I know for law research if you're interested. Sure. That's true. Chingris seems unable to accurately apply case law. And yes, and y'all know how I like to fact check something. Like I hear something and I'm like, I have to go, like, is it real? Let's look. I feel the need to do this with lawyers too, because there's a reason that lawyers have a reputation of not being very well liked people. The lawyer I spoke to yesterday, she is a sweetheart. I love her dearly. In fact, I found fun fact, my one of the partners in the law firm I'm working with used to work for the Defense Intelligence Agency. And now he's a lawyer. I mean, like, now he's a lawyer that works with the people I'm working with. It's so funny. Like, holy crap. What do you know? People hated Johnny Cochran. Yeah, well, he's just loud, if I remember correctly. Which, loud people, you know, we're not well liked sometimes. That's okay, though. In the case at hand, the plaintiffs are seeking to amend the November 9th, 2023 judgment as to Claim 3, medical negligence, Maya Kowalski, which included a $2.5 million set-off settlement of a prior settlement. That was I believe that $2.5 million, and y'all that remember this better than I do, because it's been a long time, that was Kathy Beatty's, right? That $2.5 million was what they settled with Kathy Beatty? Correct me if I'm wrong. Like, there's an oxymoron. Yeah. Oh. Angel. So I have to show y'all. She decided that she wanted to sit cross-legged on the table and eat her snack. And I'm like, usually I would grab her and stop her, but like she's just so dang cute that I just don't want to. So, you know, high five. So, however, as this motion is timely filed, plaintiffs suggest the issue being handled after appeal along with costs and any other matters. As demonstrated in the case law detailed above, applying a set-off in a negligence case where a co-defendant has settled is not the only option when calculating economic damages against a non-settling party in a negligence action. Well, I think they hate him not because of who he is and his skill level, it's who he's represented. He represented two of the most unliked defendants in, I would say, the history of the U.S. Casey Anthony and the football player, the Patriots football player. So that's the only reason. But we do like him because, for those of you who followed Vices, you knew that he was following a case of an illegal immigrant who he was here. Aaron Hernandez. Thank you. I wanted to say Jose Fernandez, and I was like, no, that's the Miami Marlins pitcher that passed away in a boating accident. So he was following, or Jose Baez represented that guy who was here illegally. However, he had his court date set and he was fine. But a cop approached him and asked him what he was doing. He was on the phone with his mom. And he was on the phone with his mom, and the cop had a heart attack, and they tried to press murder charges against the illegal immigrant, and Jose Baez took that case. And it was like that. I agreed with, like, that one. I like him. It's just, it's not some of these defense attorneys of who they are. It's who they represent and the way they choose to represent them. Like, I'm sure Casey Anthony is one of the most hated people on the planet, or in the U.S. Oh yeah, that right there. I did not know that one. I did not know who his lawyers were. No, that's mommy's dash cam. No, ma'am. We're starting the growling phase. In further support of plaintiff's argument to amend the judgment, plaintiffs cite Stella v. Crane, Florida 2nd District Court of Appeals, 1973, where the court found an error in computation of damages as a clerical error that warranted an amendment to the judgment. Additionally, the 3rd District Court of Appeal found an amendment to a judgment awarded punitive damages was, quote, to reflect the clear and mandatory terms of a controlling statute, was properly effected to correct an error therein arising from oversight under Florida Rules of Civil Procedure 1.510, Gordon v. State, 3rd District Court of Appeals, 1991. Plaintiff's request is similar to Gordon in that the plaintiffs are seeking an amendment to the judgment in an effort for it to reflect the clear and mandatory language of 768.81, which makes clear that, quote, the court shall enter judgment against each party liable on the basis of such party's percentage of fault and not on the basis of doctrine of joint and several liability. Florida Statute 768.81. Accordingly, plaintiffs request this court to amend the judgment as it relates to the medical negligence claim pursuant to Florida Rules of Civil. See? Plate just went flying. Didn't I tell you? Yeah, it's mine now. Like, it's mine now. Ugh. That's true. Like, Alan Jackson defended Kevin Spacey, but we aren't holding that against him. Technically, he wasn't on a work visa. That I understand. I could be wrong and you could be right. I don't remember, but I thought it was because that was a big point of contention in Vice's chat where people were saying, well, he's an illegal immigrant. He was an illegal immigrant who was detained, was given his court date, basically, and said, here you go. You can be here now as long, do what you need to do while you're here. You have a court date. So, hey, Madam Mayor's Adventures. How are you today? And Mr. Coop, got you on the TV listening, headed to the BC to play with Suno. Ooh, fun, fun, fun. I had to get off of Suno because it's addicting. This child, I love her. And I love her creativity and her enthusiasm and her curiosity. But sometimes I'm like, oh, you get into everything. All right. Understandably, pursuant to Federal Rules of Civil Procedure 1.54a, a trial court may not use the argument of a clerical error where correcting that error would affect the substance of the judgment. Commonwealth Land Titles Insurance v. Freeman, Florida 2nd District Court of Appeals 2004. Loving the weather. Snow is melting, 44 degrees. It's like 51 here. Oh, Discord is blowing up. Plaintiffs argue that an amendment to the November 9th, 2023 judgment would not affect the substance of the judgment. Rather, the amendment of the judgment would serve only to adequately compensate plaintiff Maya Kowalski for the damages she incurred as a result of defendant's negligence. In the alternative, plaintiffs request this court amend the judgment related to the medical negligence claim pursuant to Florida Rules of Civil Procedure 1.540b1 based on mistake, inadvertence, surprise, or excusable neglect. Florida Rule Civil Procedure 1.540b1 envisions an honest mistake made during the regular course of litigation, including those that result from oversight, neglect, or accident. Perez Mesa v. Miami-Dade County, 3rd District Court of Appeals 2019, quoting Oshwin Loan Services LLC v. Brogdon, 5th Court of Appeals 2016. Here was a mutual mistake oversight by the parties not to bring up how the settlement should or should not affect the final judgment. Wherefore, plaintiffs respectfully request this court amend the November 29th, 2023 judgment on Claim 3, medical negligence, Maya Kowalski, to no longer include the setoff provision and make the verdict. There's that Latin that I stink at, to the original date of judgment. Huh. -2 tonight. Yeah, you can actually keep that to yourself. Yeah. Y'all can come get Mother Nature out of my yard. She was drunk again and wandering around and bringing us some freezing rain and stuff, and it was no fun. So, Anderson Glenn is still handling this case, but not our friend Nick Whitney. So, with that, I did find. And this is 73 pages of fun, so I'm not exactly going to get into everything. But we will read a little bit. Yeah, but I've heard that enough times and I've read it enough times where I understand where I know what it means and I can pronounce it. When it's stuff I've never pronounced before, it's like, yeah, it's Latin. I'm not a Latin scholar. I am an occupational therapy assistant, lymphedema therapist, and corrective exercise specialist, and former handwriting expert. For handwriting without tears. Semper Fi. Yeah. That one I got. That's why Marines can say they know Latin. That's the only retroactively. And out of context, I got that. However, here's the kicker. Knowing what it means and being able to say it are two different things in my my world. Because there are things that I can say that I have no idea what they mean, and there are things that I understand the meaning, but I cannot pronounce them to save my life. So, this is a long one. So this is a bunch of exhibits. So this was filed this is 73 pages, but it's multiple. It's one of those things where the clerk of court put it in one document. This was filed on the 7th of January. Notice of filing revised response. See, reading is hard. To motion for substitution of counsel. Trial counsel Anderson Glenn LLP hereby gives notice of the filing with the trial court and its motion to relinquish jurisdiction and remand to trial court hereto as Exhibit A, and his revised motion to motion for substitution of counsel attached hereto as Exhibit B. In the Second District Court of Appeal of the State of Florida, the appellate filing for the motion to relinquish jurisdiction and remand to trial court occurred on January 6th at 7:25:52 p.m. with a corresponding file number. The appellate filing for the revised response to motion for substitution of counsel occurred on January 6th at 9:10 p.m. with corresponding file number of whatever. We don't really care about the file numbers. The vowels are pronounced like the vowels in Spanish. And that's where we go wrong, because I took German in high school and not Spanish. And the only other language that I am somewhat decent at is sign language. So it's, yeah. I always feel like when I try to speak Spanish that I'm like making fun of something. It's so, I'm bad at foreign languages, and I will be the first to admit that. I would never claim to. I have a hard time with English. Like, I gotta run, more research to do. Bye, everyone. Have a great day. Bye, TW. And I'm not gonna have this stream go on for too much longer. I have to go to work tonight. I just wanted to kind of give some updates on you want to be good at ASL. You have 8 tentacles. Well, here's the thing about the sign language. When I was a child, like, I want to say 4 or 5, my parents got divorced when I was 2. So, like, this is not a they cheated on each other situation. This is they were divorced for 2 to 3 years by this point. My dad was dating a woman who was deaf. So he was learning to sign to obviously communicate with her. At the same time that my mother was going to college to be a sign language interpreter. So when you're in those formative years, 4, 5, 6 of learning English and learning how to talk, I was also learning sign language. So I'm not fluent at it anymore, and I am slow. However, I can still get my point across. And I was getting my point across to the point where when I was working with deaf patients in the hospital, the interpreter would be like, you don't need me here. I was not signed off with the interpreter to be to work with those patients without like coming, like without hiring, or not hiring them, but ordering them, because we'd have to put in an order to get an interpreter. I never did interpreter work. I never did interpreter work, but I worked with patients that were deaf. And since I did activities of daily living with patients, including, getting dressed, changing clothes, showering, bathing, stuff like that, where the less people you have in the room, the better it is for the patient, because, it's, it's personal. So I got to the point where I could do ADLs with patients without having to, I could sign how to do ADLs. Without having an interpreter present, and all the patients needed to do was, I feel comfortable with her, you can leave. But I never got to the point where I was fluent enough where I actually went to interpreter services and took the test of where I could be a medical interpreter. So I am not nearly the skill level that she has. However, that's why I talk with my hands a lot, because when I was younger and I was learning to speak, I was learning sign language at the same time. So I automatically, talk with my hands. That's kind of where that comes from. All right. So Exhibit A. She's still sitting on the table. There's some battles you just don't want to pick. Like, she knows how to get off of it if she wants to, but like, motion to relinquish jurisdiction and remand to trial court. Trial counsel for appellees Anderson Glenn LLP moved for an order temporarily relinquishing jurisdiction solely as to this issue, remanding the motion for substitution to the Circuit Court of the 12th Judicial Circuit, and specifically the Honorable Hunter Carroll, to resolve the pending issues related to the motion for substitution of counsel filed by Childers Law LLC, the firm at which former partner Nick Whitney is now employed. Hereinafter, Movent. Movent filed for a motion for substitution of counsel on December 20th, 2024, while this appeal is pending and less than 3 months before oral argument. The motion creates issues of facts and potential violations of the rules regulating the Florida bar, including the conflict of interest issues. Current counsel asks this honorable court to relinquish the limited jurisdiction and temporarily remand this matter, and only this matter, to the trial court, since the same issues were brought before the Honorable Judge Hunter Carroll just over 5 months ago. On July 29th, 2024, Mr. Whitney loudly withdrew from this case, claiming erroneously that he had been terminated. This was untrue. He quit. See Exhibit A. Mr. Whitney's motion to withdraw as counsel, hereto as Exhibit B, also revealed information protected by the attorney-client privilege in the process. The filing prompted a response, attached hereto as Exhibit C, from undersigned counsel with an attached affidavit by Jack Kowalski. And that's what I had written, or I had read in that's what I had read when I was this is where the issues of trial counsel, appellate counsel, counsel's withdrawing is something that I am new at. Are you done? I am new at reading the documents and as to how. So this is one thing we're working through together. Exactly what is going on. Girl, I just thought you were Italian. Carry on. No, I'm German and Finnish and Ukrainian. And Czech. So Nick Whitney, back in July, Nick Whitney filed this motion to withdraw, but he filed it when Anderson Glenn says loudly, I don't think he communicated with Greg and his wife that he was doing it. And also it did kind of scream drama to me, and people were mad at me for covering it because of the fact that it started to it started to show some drama between the plaintiff's attorneys, or the appellee's attorneys in this case. So it's I'm not exactly sure how and what is happening here, and that's one of the reasons that we're reading it together, because appellate documents are not something I'm super familiar with. But the only way to get super familiar with them is to read them. I tended to stop paying attention to cases super closely when they went to appeals, but this one I just really want to follow through with it because this case is complicated, long, expensive, and has implications on the entire CPS, child abuse pediatrician, and children's healthcare space. In other words, your pedigree. You good? All right. The affidavit explained that Mr. Whitney had no knowledge and was not supposed to be involved in the financial matters resulting from this case. See attached as Exhibit D. Mr. Kowalski's affidavit pertinent part states, to the end we have communicated virtually exclusively with Gregory and Jennifer Anderson on post-trial matters, the appeal and the handling of any of our financial matters. Baby girl. Ultimately, the Honorable Judge Hunter Carroll entered an order which removed Mr. Whitney completely and utterly from any role in this case. The order attached here is Exhibit E. And part of the reason that I'm reading through this is this pretty much goes over anything that what the past few months have been doing. And I've kind of heard that, but it's weird. I feel like the Kowalskis are stuck in the middle of like parents divorcing. And I think that it seemed like Maya looked at Nick Whitney as like a big brother. And Nick Whitney is also attached to working for the firm now that is covering Dr. Goodhair's litigation. So it's just, oh yeah, Flashman, she's having a blast. And because I'm trying to sell all of her old toys, I have them sitting out on the table so I could take pictures of them. And that's why she's up on the table and she wants to get to them. She didn't want to play with them before, but now she does. To order attached here is Exhibit E, specifically instructed clerk to, quote, remove attorney Nicholas Whitney as attorney for the following parties: Maya Kowalski individually, Jack Kowalski individually. Jack Kowalski is a representative of Beata Kowalski's estate. As related to dismissed minor plaintiff KK, the order stated Nicholas Whitney no longer represents that dismissed plaintiff. For nearly 5 months, the relationship between the undersigned and the Kowalskis could not have been better. The relationship included assisting the family at their request on multiple matters during college applications for Maya Kowalski, and her staying with undersigned's sister and brother-in-law as she considered California schools, chiefly UCLA. The recent circumstances of the Kowalskis suddenly, quote, going dark around Thanksgiving, and a few weeks later, the undersigned receiving a letter from Mr. Whitney and his new employer discharging undersigned, raised substantial issues of ethics, confidentiality, and procedural necessities that could be better resolved by the trial court. Sorry. It's time for you to get... Come here. Girl, you're gonna fall. She's mad because I took... You lost that too? This is where you pick your battles, right? Come here. She's you're gonna tip it over. You're not gonna be able to get down. Be right back. We're having a meltdown, a very big meltdown. Baby girl, come here. Come here, silly bug. She mad. She big mad. Oh. I used to hide some of the kids' toys and rotate them. They felt like I do that pretty often. I have a closet full of toys that I rotate in and out. These are ones that are no longer developmentally appropriate that I'm trying to sell because they're in really good condition and I have no one to give them to, and I don't want to throw them away. So I was going to post all of them and, say, best offer or $20. Like, here, just take them. So here's the drama. Yeah, Squidlid declared war. That's what it's felt like all day today. So what it sounds like is the Kowalskis didn't tell Greg and Jennifer Anderson that they wanted to go with Mr. Whitney. They got a letter from Childers, the new law firm that Whitney works for. So it's it's one of those, like, it is you'll figure it out. You'll figure it out. I feel like you figure things out. Like, there is no handbook for how to do this. I mean, people write books, but that doesn't mean they're correct. But you figure it out. That's when I put on Baby Einstein on the iPad and just deal with the guilt I felt about it. Yeah, that's what she has on her. Well, we don't have Baby Einstein, but Coco Melon and that kind of stuff on her iPad. But her iPad is attached to mine, and she's not allowed. I don't do YouTube Kids because I don't think I can monitor it as safely. Once Upon a Time, do you have those there? We don't. There are some consignment shops, but a lot of them are full. Like, I actually went to a consignment shop where they were no longer like taking certain sizes of clothes because they just had too many. So it's like we're possibly moving. Well, our house is for sale. Like, we're moving sometime. I just don't know when. So it's one of those things of like, I want to get rid of everything that I don't want to take with us. So you're fine. Hi, Mary. How are you? A lot of trolls on YouTube Kids. Well, I don't know how easy it is to monitor it, whereas she's on my YouTube account. So I can go into my phone and I can go into my YouTube and see what she's watched instead of having to like set something up where I can monitor her. I can just monitor her from my phone. And I can see what she's subscribing to, which she doesn't really understand that she's subscribing to, but YouTube Kids has it on rabbit holes. And hey, Melissa Joy, I got no notice of your stream. YouTube needs a good slap. Yeah, and I thought when I was in the expert stream last night, I thought I was setting it up then, and I thought I hit save stream, and when I went to like look at it this morning, like apparently I hadn't actually set it up. I did everything, but I never hit like, set up stream. So usually I would set it up and then people would have more of a notice, and I would also post it on Twitter and my Discord, and I just didn't. The Kowalskis are most likely frustrated with how long this is taking, which is understandable. And maybe they just want to try a different approach. They should have communicated that with Greg, though. Yeah, it just seems like I just don't. And I feel like they've been dealing with this so long that they're over it. So, but I don't know exactly. Once again, I'm not in their heads. I don't know them. I don't speak to them. So we don't actually know what they're going through. And I can't imagine it's easy from any means or by any means. Current undersigned counsel suggests that a relinquishment of jurisdiction and remand for the limited purpose of resolving the matters related to the motion for substitution of counsel would expedite the disposition of this appeal, since Judge Carroll has already addressed the matter as explained above. Finally, if there were to be a substitution, the trial court would be in the best position to condition any substitution on the reimbursement of costs, protection of fees, and enforcement of confidentiality agreements, and appointment of financial institutions to receive funds, if affirmed, as contemplated under Rule 2.505(e)(3) of the Rules of General Practice and Judicial Administration. Wherefore, the reasons stated herein, undersigned counsel respectfully request that this honorable court enter an order remanding this to the Circuit Court of the 12th Judicial Circuit and to Judge Carroll's division for the purpose of allowing the trial court to resolve the pending issues related to the motion for substitution of counsel. And part of the reason that I hated covering this was I did not want this. Like, this is frustrating to me in the sense of it's like two parents fighting. I feel in some way it revolves around money. Yeah, I don't disagree. I don't disagree. So here's Exhibit A, and I'm going to cover the email addresses because, Nick, I was on the call with Jill after the rather unexpected and aggressive text you sent. We assumed you were quitting. We never told Jill you were fired. Greg only instructed her to turn off computer access until we figured out your mindset. She made an incorrect assumption without authority from any partner. When you relayed you weren't quitting the very next day, Greg instructed your computer to be turned back on, which Marty did. You have not been terminated. Any action of leaving the firm is on your own accord. It is disappointing that any of this is happening. Jennifer. Good morning. Following my termination from the firm on Wednesday, July 10th, we are required under Rule 4-5.3C1 to cooperate in the drafting of a joint letter to the clients whose matters I primarily handled, notifying them of my departure and giving them the choice to continue with Anderson Glenn or elect to have me continue in their representation. To that end, attached is the Florida Bar's template letter, modified to fill in the firm's name and mine, as well as contact information. Blue text indicates information the firm will need to fill in. Please reply by close of business tomorrow with suggested revisions, if any. I requested a list of, well, it's not me, Flash Fan. It's like I got a stream demonetized for showing my own email address. So I try to not do it, even though their email addresses are public knowledge. Like, these are their work email addresses. These are not their private email addresses. Like, these are, things that easily could be looked up on any of their firm's websites. But, this is exactly what JHACH wants and plays right into their hands. They want the Kowalskis so frustrated and desperate that they'll settle for anything to end it. I feel the exact same way. And I hate it's like when people on one side of the current drama situation argue with each other, it plays right into the haters' hands because that's what they're looking for. They're looking for you to infight so they have something to talk about. Yeah, winning a lawsuit isn't really winning. Yeah. So this was the motion from July. So I'm not going to read that again because we all know what happened. So it was dramatic and I already went over it, so I'm not going to do it again. Plaintiff's motion to strike withdrawing counsel's motion to withdraw and order prohibiting any further filings. So this one I also read. Basically, they wanted to stop Nick Whitney from being able to file anything. And it's just, yeah, you can win a judgment, but collecting on such judgment, different story. And sometimes it is just the point of the matter. Like, you proved a point. You're going to stop this action from happening in the future by winning, which is one of the things that can happen here. And I'm hoping that this has an impact on children's hospitals all over the country, their child abuse pediatricians, that whole shit show of a profession. And that's my opinion. Child abuse pediatricians are shit. You heard it here first. So if I ever take little baby squid to the doctor and we have an issue, you heard it here first that it's retaliation. So I actually talked to my pediatrician about this case. And I mentioned this case, and because I have chronic pain issues and chronic health issues, that if she starts exhibiting anything, like, I've talked to you about being nervous about doctors. So, because I had a problem with the ER doctor when I took her to the ER, she got diagnosed with the COOF in 2022. she was 6 months old, and the doctor blamed her dad for not having the Fauci ouchie as the reason that she got sick. It's like, all kids get sick. This is just what she got sick with. And she was like practically berating me for not having, for her dad giving her the coof. It's just so bizarre that I can't even like, I was about ready to go Karen and ask for that doctor's like boss and medical license number and all of that. Like I was about to go full Karen. It's possible. She's there. She's there. She doesn't like to come out, but she does on occasion. So he mentions things like withdrawing counsel failed to consult with the counsel for the Kowalskis regarding the release of information in his motion before filing it, but instead cited a conference with opposing counsel, specifically C. Howard Hunter, Esquire, as the basis for revealing confidential information. So this went down dirty. And I had people commenting on that video pissed that I read this. And it was one of those things of like, I'm sorry, but like, this needs to be, and if you don't like public information getting out in public documents, don't fuck around and find out. Like, yeah. Needless to say, we've never spoken to that doctor again. And I immediately, well, not immediately, but the next time that I had spoken to our pediatrician, I mentioned it because the pediatrician's office and the hospital are right across the street from each other. So this was these are all these motions. Exhibit A, the affidavit, and I will post this in the Discord server, but I will probably have to do it after I get home from work tonight because it is Tuesday, and on Tuesday nights I work. So, like order directing clerk to update plaintiffs. There's a lot here. So this is basically everything that has to do with what happened in the last 5 months between the plaintiff's attorneys. So, yeah. Current counsel revised response to motion for substitution of counsel. It's just, there's a lot. And here, this is the one that I think we should actually read. Trial counsel Anderson Glenn LLP hereby submits the following revised response pursuant to this court's December 3rd, 2024 order and Florida Court of Appeals that's legal term, like legal stuff that my brain cannot comprehend right now. Objecting and moving this honorable court to deny the motion for substitution of counsel filed on December 20th of 2024 and remand for the motion to the trial counsel and in support thereof states as follows. Following Mr. Whitney's departure from the undersigned firm, the Kowalskis went dark a few days before Thanksgiving. The undersigned has heard nothing from Maya Kowalski since that time. Even for the past 7 years, they had monthly, if not weekly, conversations either by text, email, or phone. Jennifer Anderson's relationship, considering Maya no longer has a mother, was even closer. Okay, this is just me being finicky, but like to put this in there, considering Maya no longer has a mother. I know he's a lawyer and lawyers are generally straight to the point, but knowing this is a public document and knowing that the following that this case had, and this was probably going to be read by somebody, that's a really shitty way of phrasing that. I would not have said that. I would have said Jennifer Anderson's relationship was closer considering the circumstances of Beata's untimely death. That was petty. Like, But do you notice petty knows, like petty can see petty? So my petty side goes, oh, that was petty. Like that was phrasing. Yeah, that was pretty petty. And he might not have meant it like that, but my petty side sees that as a petty comment. These circumstances of sudden silence are suspicious, to say the least. Thus, the concurrent motion for relinquishment of jurisdiction and remand to trial court. Although the purported new counsel's motion specifically represents that the undersigned were contacted by the movant before filing the motion to discuss it prior to filing, the undersigned counsel has never spoken to either Mr. Childers or Mr. Whitney about the motion, nor received any emails or text other than a one-page directive below. True, 5 months ago, Mr. Whitney emailed claiming termination and made attempts to take clients. But and I'm sorry, but unless there was something that wasn't filed that was like text messages between them, I don't think Mr. Whitney tried to take. He even cited where they had to file paperwork that they were both on a legal team, and the clients could either choose to stay at Anderson Glen or move to a different firm with Mr. Whitney. That to me does not seem like Mr. Whitney was trying to steal clients. So that to me is a petty statement too. And this is not in all the things I've ever written that or ever read that Greg Anderson has written, none of it sounds like this. This sounds like jealousy, and this is not his normal. He sounded mad when he wrote this. His normal filings are not like this, in my opinion. True, 5 months ago, Mr. Whitney emailed claiming termination and made attempts to take clients. But any issues regarding the representation of the Kowalskis were resolved by the order dated July 30th, 2024 from the trial court. But as this is the second attempt to gain control, there has been no attempt to meet and confer in violation of Florida Rules of Professional Conduct 4, 5.8c. And the requirements for this court to attempt to resolve the motions before their filing. Well, let's see here. Because of bubble brain, I have to I just had to return a text real quick. Okay. Hi. Everybody decides to message me all at one time. Why does that always happen? Like nobody messaged me all morning, and then all of a sudden it's here we are. What the hell's Florida Rules of Professional Conduct, Chapter 4. So let's see 4-5.8c. Let's see what it says. Let's stop sharing this, and we are going to share this. Florida Rules of Professional Conduct 4-5.8c. Contact with clients. Lawyers leaving law firms, absent a specific agreement otherwise, a lawyer who is leaving a law firm may not unilaterally contact those clients of the law firm for purposes of notifying them about anticipated departure or to solicit representation of the clients unless the lawyer has approached an authorized representative of the law firm and attempted to negotiate a joint communication to the clients concerning the lawyer leaving the law firm, and bona fide negotiations have been unsuccessful. Okay, well, I think in Nick Whitney's email, he did try that. Back in July, he had written that said, hey, we need to, pursuant to this, we need to fill out some paperwork and give the clients an option. Yeah, sometimes. Depends on where you are and what you're writing and if you're writing. So dissolution of a law firm, that's not appropriate. So it would be paragraph 1. So it doesn't strike me as I don't think that this is going to go very well for Mr. Anderson. Rather, within 26 hours from that first contact by means of the directive that Childers Law, a 2-person bankruptcy firm in Gainesville, was now counsel to all 3 Kowalskis, 4 counting the estate, the purported new counsel filed the motion at issue in this court. Significantly, Movens failed to direct this court to Judge Carroll's prior to July 30th, 2024 order itself a violation of Florida Rules of Professional Conduct 4-3.3. As to the duty to bring the material facts to the tribunal's attention and Florida's Rule of Appellate Procedure 9.380, as to notice of a related issue or ruling. For these reasons, the motion should be stricken and or denied with instructions for the allegedly new counsel to follow the rules of professional conduct and rules of appellate procedure. Upon receiving this thunderbolt out of the blue, the undersigned reviewed recent cases the firm is defending on behalf of the appellee Kowalskis and noted that Childers Law LLC, hereinafter Childers Law, has a direct conflict of interest under Florida Rules of Professional Conduct 4-1.7A1. Attached hereto is Exhibit A. A complaint is filed in the 6th Judicial Circuit for Pasco County on November 6, 2024. Moven here entered an appearance on behalf of Trilogy, a trial support company that edited and showed depots at the underlying trial and ultimately charged the Kowalskis more than $200,000. The undersigned objected to the charges as an agent and representative of the Kowalskis as the bill is outrageous. This is just crazy. Though it names the Kowalskis' undersigned trial counsel as the party defendant, it is adversarial to the Kowalskis' financial interests. It is clearly a trial cost that is owed by the Kowalskis once the amount is settled. Attorneys are agents for their clients for all purposes, especially for this nature. Florida Rules of General Practice and Judicial Administration 2.505H. Movent cannot sue its own alleged client, whether he's putting alleged in there. I mean, that's petty, whether directly or through client's long-standing agent. Further, the undersigned has some suspicions regarding the signature of Maya Kowalski attached to the motion, although due to the holidays and with knowledge of a life-threatening illness of Jennifer Anderson Esquire, the undersigned begs the court's indulgence as it's hard to manage family and a very sick wife over the holidays and locate appropriate experts. Current counsel has yet to have a handwriting expert review the signature. Will if given the opportunity, but that does not mean he should not raise the issue. Sweet Jesus. Based on the fact that the undersigned has reviewed and observed the signature of appellee Maya Kowalski on countless occasions over the past 7 years, that does not appear to be her signature endorsing the motion. Alternatively, it does not appear to be an original, but perhaps one transferred from another document at someone's discretion. That is a very, very, very that's a very big accusation to throw around. That's a very big accusation to throw around there, Mr. Anderson. And to be honest, whether this is true or not, plain devil's advocate, she has CRPS. One day she might be able to sign her name, and the next day she might not be able to write. So when she has to sign something and she's in a lot of pain, y'all know who have chronic pain, like when you're able to do something one day, you are not able to do it to the same effectiveness or quality the next. So I'm playing devil's advocate. Don't assume anything. But that is a big assumption and big accusation. The undersigned is bolstered in his belief that he has this personal knowledge of Maya Kowalski has been living in California for large portions of the past 3 months at the home of undersigned's sister and brother-in-law in Rancho Santa Fe while she explores choices of universities. Yeah. I know, right? Like, using his own words against him. Like, and I'm sorry. Like, just, I don't see Nick as the type to file some, yeah, they better be ready to prove that. Yeah. And I'm sorry. I've printed some things out, signed them, and scanned them, and it can distort the way your signature looks too. So if she's been in California, say she signs something, scans it with her phone, and emails it back, things can change. I suffer from CRPS. I'm so sorry. I hope you are having a good day today. And my signatures can be different. I can have bad days. Exactly. My take is that he is definitely questioning the validity of the signature. He wants a chance to use an expert. And I understand, but this phrase right here, at someone's direction. If he would have just said, alternatively, it does not appear to be original, but perhaps one transferred from another document, I would have been like, okay. But this one, right, this last phrase right here, at someone's direction, screams petty to me. And it takes one to know one there, Anderson. The undersigned is bolstered in his belief in this is he has personal knowledge. Maya Kowalski has been living in California for large portions of the past 3 months at the home of undersigned's sister and brother-in-law in Rancho Santa Fe while she explores choice of universities. It is the intention of the undersigned counsel to have her signature reviewed by a handwriting expert as soon as is practicable. It may be well that the signature provided in the motion is appellee's signature, but until the circumstances of the 19-year-old appellee's consent are investigated, oh, she's 19 now, the motion should be stricken as to Maya Kowalski. It's just one of those, like, it's like when Bubbles was asking questions, and it's like the way of phrasing things was like, you could have asked that question a lot easier, but you needed to get some stuff in. He could have left off that last part, and the question would have had the same merit, minus the petty. Like, the state, yeah, all this added stress will not be helping her. And that is the thing, too. Like, she's an adult now, but I'm sorry, she's 19. Like, she's still a kid. And I never thought I would say that. You know you're getting old when you call a 19-year-old a kid. Given the importance of a voluntary, knowing, and advised and properly managed transition, any question in this regard should be resolved in favor of the forbearance of change of counsel after a 7-year successful relationship. Factual issues predominate traditionally the role of the trial court, particularly as here, where the trial court already has once decided of the issues. Yeah, well, I'm pushing 40, so, you know. I find it suspicious that they chose the firm that doesn't seem to have the skill set for a case like this. Well, it's not the firm, it's the lawyer. It's not Childers Law, it's Nick Whitney. I also find it interesting that if you remember about a month ago, we read through the initial filing for Dr. Goodhair's lawsuit about his wrongful termination and his money that went bye-bye. He is using Childers Law. So, and he is being represented by Nick Whitney, which is interesting. So there is a lot of things that I think even in the filings we are not there's a lot of interpersonal relationship issues that there's problems with. So, yeah. I'm not even going to speculate on what those are. I don't talk to any of these people, so I have no insider knowledge to that. I do know people who do talk to them or have talked to them. I am not one of those people. I didn't have a channel then. I was not special enough to be one of those people who got to talk to Nick Whitney. However, he's former Navy. I'd like to talk to him if given the chance. Not even about any of this. This would be like secondary. But Nick Whitney, I'd like to ask him some questions about his background. These issues should be placed in the context of the trial court's prior resolution of the issue. See motion to relinquish jurisdiction and remand to trial court filed herewith, but additional facts include Memorandum of Law. Undersigned counsel for the Kowalskis has represented family since May of 2017 when the first spoliation in 627.4137 letter went out, culminating in them serving as lead trial counsel in the 8-week jury trial in the fall of 2023, of some repute resulting in the Netflix documentary Take Care of Maya. Undersigned counsel for the Kowalskis filed suit in 2018. Over the course of the 7 years it took to get the case to trial, including a writ of Yeah, this one's got me. Hey, Tammy. And Flash fan, honestly, I would love to talk to her. Even about that last part. I think just like you and I, she and I would have more in common in that regard than I think we would ever know just based on identity politics, if you know what I mean. The undersigned counsel and the firm worked tirelessly in hopes of obtaining a favorable verdict for the Kowalski family, which included litigating over 3,800 and counting docket entries. The undersigned succeeded, subject to this appeal, of course. The combined docket of approaches 4,000 entries and at the combined trial and appellate level. After the incredible financial constraints of supporting the millions of dollars of costs and deficit spending of the firm, the Andersons sold their home on the Intercoastal Waterway to downsize their costs of living and accommodate the multiple lines of credit necessary to keep the case going and the firm of Anderson Glenn LLP alive. Mr. Whitney was a former partner of the undersigned firm. Mr. Whitney had nothing to do with bringing the Kowalski matter into Anderson Glenn, and he was not even employed there at the time. As a second-year associate, his role was to support. Even upon eventually making partner, he had no direct responsibility for any aspect of the case. Any involvement by Mr. Whitney was carefully supervised prior to this case. Mr. Whitney had one case where he was the first chair jury trial, carefully selected for him because it was a rear end stipulated by liability whiplash case, which the undersigned believed to be unlosable. Mr. Whitney lost. Way to throw shade. Like, way to throw shade. Way to throw shade. Like, oh. After now almost 8 years of dedication to the case and the Kowalski family, undersigned counsel and firm achieved a favorable verdict during the 8-week jury trial in the fall of 2023 of $261 million remitted by the trial court to $209 million. Okay, that was the remittance. The remittance was the $41 million or $42 million. Yeah, petty. Like, petty. And I can understand in a way why he is upset, because this probably should have never freaking happened. Whatever that incident was to spark that text response by Nick Whitney, which set all of this in motion. This is petty. And unfortunately, because I like all these people, and I think they have done good work, this I don't like. This I do not like. Where if it was like Howard Hunter and Ethan Shapiro bitching back and forth and being petty, I'd be all here for that, because I don't like either of those two. Howard Hunter and his skeletons, or the Dracula he thought he buried. Oh my goodness. Breathe. Subsequently, Undersigned's counsel selected appellate counsel and worked with the Gunster firm in identifying and responding to the likely issues defendant appellants might raise on appeal. After sitting second chair at the 8-week trial over the fall of 2023, Mr. Whitney quit Anderson Glenn LLP in mid-July of 2024 without notice or the customary 2-week pre-departure period to allow a smooth transition of clients. Undeterred, Mr. Whitney proceeded to file a noisy withdrawal from the trial court in his first attempt to client grab. Since he was never individually counseled to the client, his withdrawal was not only unnecessary, but in it he revealed privileged and confidential information. In response, Jack Kowalski filed a detailed affidavit making it clear he was staying with Anderson Glenn LLP. The trial court made quick work of Mr. Whitney's attempt, ordering he be removed from any representation. See exhibits to undersigned concurrent motion to relinquish jurisdiction and remand to trial court. Jeez, this is petty. The reply brief on the merits of this appeal was filed on September 27th of 2024, concluding the briefing process. The undersigned was and remains involved in representing Maya Kowalski in a number of matters, but then received a December 19th, 2024 letter where they were informed that he, his wife Jennifer, who had been a second mother to Maya and the firm, were being replaced by Mr. Whitney and his bankruptcy firm in Gainesville, Florida, Childers Law. It is now only after virtually all the work that has been completed that a letter not from the Kowalskis and without explanation arrived, notifying Anderson Glenn LLP that Mr. Whitney's new firm would be taking over the matter. Current counsel has heard absolutely nothing directly from the Kowalskis concerning any issues, any objections, any controversies, indeed any problems whatsoever prior to allegedly being discharged, at least until last week when Mr. Kowalski sent an email with banking instructions. They are no doubt following the instructions from Mr. Whitney and Mr. Childers to refuse to communicate with the Andersons and the firm. Heaven only knows what Mr. Whitney and Mr. Childers have told our clients, whom we have given everything. The firm, claiming to now be new counsel, never called to explain or discuss the motion before filing it, but instead only forwarded the directive, see affidavit of Gregory A. Anderson, Esquire, attached here to is Exhibit B. The letter was received via email on December 19th of 2024 at 1:07 p.m., and the physical letter was not received in the mail until the morning of December 27th, over a week later. The letter did not include the motions for substitution of counsel for current counsel's review, nor did it ask if current counsel had objections. Current counsel has received no phone calls, no emails, no text, nothing explaining the basis or requesting a conference to discuss issues amicably resolve them. And the same was true from the Kowalskis. Nothing, despite the fact that there has rarely been a week, or even at critical times, a day without communication since this case was filed in 2018. The letter does order the undersigned not to contact their client, and the clients have refused to respond to text, emails, or calls. Less than 24 hours later, and without waiting for a response from current counsel, Childers Law filed the motion for substitution of counsel with the trial court. Sweet Jesus. After I get done reading this part, I have to get going. It's that time of day. But this just is bad. The statements made in the motions for substitution of counsel are material misrepresentations made in violation of Florida rules of professional conduct. Paragraph 4 of the motion states Gregory Anderson, Esquire, and Jennifer C. Anderson, Esquire of Anderson Glen, have been notified of this motion for substitution of counsel and oppose the substitution of counsel. This statement is a material misrepresentation of fact to this court. See affidavits of Gregory A. Anderson attached as Exhibit B. The above detailed representation makes it seem as though current counsel was provided with the motions for substitution of counsel before it was filed and given a reasonable chance to communicate their objections or attempt to resolve it. They were not. Yeah, I agree with you. There is much more to this than what's being said. And I wonder if Megan knows any of this is going on, because she hasn't. It's not just Megan. There was multiple people in LawTube that were talking about this, that covered this trial. There was even arguments about this trial between lawyers. And since about March of last year, it has been absolute radio silence. Everybody kind of went dark. And of course, there was things like the Laura Owens case that kind of took over the mainstream. However, everybody went dark. Megan was even on her locals reading Iron 44, which was Greg Anderson's book about a case he won in California. Here, you can have a little bit. But she even stopped doing that. So there's more to this story that we don't know. Take a drink. But you can't have the whole thing because you've spilled it 3 times over the last 2 days. Come here. Come here. Come here. Okay, then don't come here. Yeah, don't forget Sarah Boone. Yes, there was Sarah Boone. Oh yes. I completely forgot. I'm so sorry. Mo was covering it, blonde wig and all. Yeah. As set forth above, the undersigned counsel was given less than 26 hours from the receipt of a terse letter to the filing of the motion over Christmas vacation, with the knowledge that A, the Andersons were in Idaho visiting relatives for the holidays, and B, Mrs. Anderson was and is extremely ill. It should be further noted, and Jennifer Anderson, I hope you do get to feeling better. Not like you're going to see this, but it should be further noted that at no point in the letter did a new counsel even ask if the undersigned had an objection. Rather, the letter curtly stated the undersigned was no longer counsel and was not inviting a response on the matter. While undersigned objects to the substitution of counsel, the representation made in paragraph 4 makes it seem as though the new counsel and undersigned counsel have spoken on this matter. They did not communicate in any form. In light of the conduct described above, current counsel would like to direct this court's attention to a 2018 Supreme Court case where the court found an attorney violated the rules regulating the Florida bar when he knowingly made a material misrepresentation to the tribunal in a proposed order by stating the counsel for the defendant has interposed no objection to the motion. Florida Bar v. Peterson, 2018. I'm not letting you have that, Angel. Sorry. You're okay. You're okay. Here. No. In actuality, the attorney failed to give counsel for the defendant any notice on the motion, thus making it impossible for defense counsel to state if they had an objection or not. The court found that the statement made in the proposed order was a material misrepresentation in violation of Florida Bar Rule 4-3.3a, 4- 8.41 and 3-4.3. While the representation of the movement Childers Law is correct, the undersigned do object. It is the fact that there was no notice or discussion that is concerning. Are you okay? Oh, somebody's sleepy. This is what happens when we don't take a nap. We start getting sleepy and moody. I think we're going through a growth spurt because we've just had, this has been all day. She's not satisfied with anything. She wants to be up, down, sideways, upside down. Like, can't fall asleep, won't fall asleep. All this kind of stuff. Ugh. No conversation has occurred with current counsel between any of the involved parties. Current counsel has not heard from the Kowalski family regarding their discharge as counsel. In the letters from Childers Law, current counsel was informed that they were not permitted to communicate with the Kowalski family. As such, at this time, current counsel remains completely in the dark as to why and how the decision for substitution of counsel was made. Current counsel has attempted to contact Childers Law since the receipt of the motion for substitution of counsel, but has not received a call back. And that's kind of shady on that part. So if Nick represents them on the appeal, will he be the one getting the attorney's fees when it's finalized? Or is Greg just worried Nick might lose the appeal? Based on the fact that he mentioned that the first case he ever tried alone, or that he was first chair on, was unlosable and Nick Whitney lost, I think it's both. I think he's concerned that they're going to lose it, but also, like, I would want to know what, oh yeah, but we haven't figured out that taking a nap will make us feel better. We haven't linked those two together. The representation made to this court in paragraph 4 is misleading to the tribunal, as there has been no communication. New counsel should be prohibited from representing the Kowalskis due to a current and direct conflict of interest. Current counsel, okay, just getting to this, I can tell that Greg Anderson is pissed. I can tell through his writing that he wants to be vindictive, that he is being petty, and I understand why he's upset if what he's saying in here is true. However, with that being said, I don't know if I would try to run a former partner's name through the mud and take and introduce my clients or what people I viewed as family for the last 7 years I don't know if I would do this to them, because this is giving JHACH ammunition for drama. And yeah, and Hunter and Shapiro are sitting back eating popcorn, shaking my head. Yeah. Like, yeah. Hey, Chrissy. Late, but hello. Squid squared. I like that. Everybody says hi. Oh. She's like the thumb in the mouth. So the band broke up and they're fighting over the pieces. Yeah, and it sucks. And I just don't know if that's the other question. And here's my other question. That affidavit was signed back in July by Jack. But as we know, Jack is only 2/3 of the equation. He's individually and he's the representative of Beata's estate. But Maya is the other party here. And what if Maya wants to go with Nick and Jack wants to stay, and there's that too that I didn't even take into consideration until now. So it's oh, thank you. I appreciate that. And she's a toddler, so what are you going to do? Like, you got to pick your battles. Like, Current counsel would like to bring the following current and direct conflict of interest to this court's attention. The alleged new firm, Childers Law, is representing Trilogy Trial Consultants in a matter against undersigned counsel. Oh, there's more drama. Hey, Wise Angel. Attached here to is Exhibit A. Super is a complaint filed on November 6, 2024 by Childers Law on behalf of Trilogy. The action in the attached complaint arises from Trilogy's roles as the trial support company at the Kowalski trial in the fall of 2023. Trilogy submitted an excessive bill, which the undersigned counsel objected to on behalf of the Kowalskis. That is an interesting turn of events, though. And why would you? I don't know. Procedural issues will come with receipts, and I'm sure, and probably an attachment to this filing. However, those won't affect the outcome, in my opinion. And I know they probably won't affect the outcome. However, to me, this is like bad optics, almost peculiar optics, shall you say? As counsel for the Kowalskis and pursuant to Florida Rules of General Practice and Judicial Administration 2.505H, the undersigned firm has been charged as the Kowalskis' agent in all court proceedings for the past 7 years, and such. Part of the firm's responsibility entails protecting the Kowalskis' financial interests, including disputing excessive fees and costs associated with litigating their case. Angel, she's pushing everything off the table, which means not this. You do it to yourself. All toddlers are a little bit schizophrenic. 2 of my grandkids are around the same age. Yeah, it's the attention span is, but she's now throwing everything off the table. But baby girl, I need that though. Oy. In upholding that duty, the undersigned firm disputed the bill sent by Trilogy as excessive. Such dispute was made in good faith after sending the bill to 2 other trial support companies for review, who confirmed the bill's excessive nature. Anderson Glenn has paid the amount believed to be reasonable regarding the work done at trial and has further attempted to amicably resolve the dispute. Those attempts have been clearly unsuccessful. As a former partner in the undersigned firm, Mr. Whitney knew the concern for the amount charged by Trilogy and its exaggeration of services, meaning Mr. Whitney is a material witness. Mr. Whitney's new position at Childers Law creates conflict for Childers Law representation of both the Kowalski family and Trilogy. No. Nope. Did y'all see that? Angel, you gotta stop that, please. Stop, please. I'm gonna take it away. Then stop. Oy. All right, I think we have at this next section. I'm going to stop because I have to get going and I have to make sure she does not destroy anything. Next, under rule regulating the Florida Bar 4-1.7A1, a lawyer must not represent a client if the representation of one client would be directly adverse to another client. This conflict is imputed by the entire Childers Law firm. The amount in controversy for the matter raised by Childers Law on behalf of Trilogy is approximately $200,000. While the lawsuit is pled against the undersigned firm, that money would come from the pockets of the Kowalskis as a trial cost. Further, the effort by Trilogy was for the benefit of the Kowalski family, as noted in paragraph 36 of the attached complaint. Mr. Reyes assured Anderson, "I will make sure we have the tools we need in the courtroom to put on the very best visual presentation for Maya and her family. Therefore, as an adversarial relationship exists between the reported new firm and the Kowalskis as represented by their current counsel. Why is someone getting onto that beautiful, innocent baby, the little angel? She is almost about ready to destroy the box that contains my Christmas gift from my dad, which is a front and back dash cam. Which I need to have professionally installed because it's way over my head and there's a lot of wires, so it's sitting there. Yeah, you backed that up and saw that. And she went between me, the mic, didn't hit my computer screen, but between my computer screen and this, which is about an 8-inch gap. I don't know how she did that, but she did. So yeah, and that was like. I hope somebody will go back and clip that. Undersigned counsel is aware of the exception for informed consent detailed under 4-1.7b of the rules regulating the Florida bar, but no facts have been offered to demonstrate either party knows of the conflict, provided consent, and subsequently waived the conflict. In any event, suing one's own client, even though their agent, cannot be waived. The comments to rules regulating the Florida bar 4-1.16 state, even if the lawyer has been unfairly discharged by the client, a lawyer must take all reasonable steps to mitigate the consequences to the client. In keeping the aforementioned comment in mind, an undersigned sincere interest in doing what is best for the Kowalski family, as up until recently, they had been devoted clients to undersigned's firm. Undersigned believes it's his duty to ensure the Kowalskis were made aware of this conflict and provided proper informed consent pursuant to Rule 4-1.7b. And that right there is where I'm going to I'm going to stop for the day, because we went through quite a lot. And thank you for the 36 people that are still hanging out. Baby Squid needs to be in the NFL one day. Meh, you know. We'll see. So if I recall, we had this issue come up locally where a firm member was representing the county while a member of the same firm represented the plaintiff developer if court found it was a conflict. Yeah, and I have opinions about this, but I like both parties, so I'm going to kind of bite my tongue. I will see you guys on the next one. I will probably do the rest of this tomorrow because we have a lot to catch up on. This is a drama that I didn't realize existed until I just went deep diving the other day. And I was like, oh my goodness. So we have documents and stuff to catch up on in a lot of Florida cases. So I will be doing this tomorrow and possibly redirecting myself to a stream, another stream talking about another Florida unaliving case, but we will see how it goes. Either way, little one decided she wanted to play with Chandelier. I gotta go. I will see you guys later. Have a great afternoon. Remember, I love you guys. Stay safe out there and be kind of a bitch. Bye.